All right. Let's talk about the Penobscot Nation River case that's been in the news for the
Mm-hmm.
past, I don't know, how long? A couple of years?
Couple of years since 2012.
Yeah. What's your thoughts on that?
From the beginning?
Well,
Well, I think that one of the things that we've been trying to do in educating people, we've gone all over the state, New Hampshire, Canada with the film, and
what film is that now?
the Penobscot Ancestral Waters Contested Territory, made by
Okay.
Sunlight Media Collective.
Okay. Now, is that on YouTube or can
You
you?
can access it through the Sunlight Media Collective website for free. You can watch it for free, sunlightmediacollective.org. There are also screenings that have been going on across the state where we do Q&A after to answer questions about the legalities of the case with people who are coming forward. There are so many things tied to this case that are problematic. And we'll start at the very beginning. So there is a recognition in Maine v. Johnson case, which is a 2007 case, that recognized the territorial waters of the tribe. You can't have territorial waters without water. And so the Maine Supreme Court recognized the territorial waters of the tribe and that the state's jurisdiction went south to the territorial waters of the tribe in regard to the output of pollution into the Penobscot River by industrial actors. And so that's recognized in this case, Maine v. Johnson. And then the Bureau of Census also recognized tribal lands and territorial waters. And so you have the state of Maine and the United States government both recognizing territorial waters of the Penobscot Nation within the last decade. And then all of a sudden, in August of 2012, Maine Governor LePage, and it was Attorney General Schneider at the time, issued a statement claiming that the tribe did not have any territorial waters associated with its reservation or within the boundaries of its reservation. And what happened the month before this was that Enbridge Line 9 tar sands pipeline that goes from the west to the east in Canada was approved. That reversal was approved. So they would be able to pipe tar sands from the tar sand fields in Alberta in the west through to the east in Canada into these ports out of St. John and out to these foreign markets. None of that stuff is staying in the United States or Canada. It's all being shipped off to these foreign markets. And so that was approved, and LePage and other representatives from his administration went to Canada, met with Canadian officials, and they met with representatives of ExxonMobil in July of 2012. A month later, in August of 2012, after coming back from that meeting, the Attorney General's office issues this statement that contradicts a previous statement recognizing the tribe's sustenance and subsistence fishing rights by Attorney General Tierney. In addition to these other cases and this other acknowledgement of our territorial waters. And it became pretty clear to a lot of people because where Enbridge Line 9 stops right around Montreal, there's a direct line that goes over to Cobourg Gore, which is where the east-west corridor was proposed to go from Cobourg Gore to Calais. This half-mile wide industrial corridor that they claimed was just going to be a highway. You don't need a half a mile for a highway. And they called it an industrial corridor and not a highway on purpose because they were trying to be deceptive about what their intentions were. Well, there were some plans that were released from a company called DCP Development that does development plans for these oil and gas companies. And there was a plan that was released where one of them took Enbridge Line 9 right over to Cobourg Gore and took it directly across the state into Calais and then connected with the St. John there. The other plan, it went all the way up around the state of Maine to through New Brunswick and over to St. John. And that would have been a lot more costly to go up around than to just go this direct route. So it is assumed that the reason that the state of Maine issued this statement was because they intended to make an agreement with ExxonMobil to move that tar sands across the state of Maine through this pipeline that would go through the east-west corridor. And that would have to cross tribal lands in a number of places, but more importantly, it would have to cross the Penobscot River. And so it was in their interest to try to strip away, it was a proactive, preemptive strike against tribal water rights to try to take that away. And so there are canons of construction under federal Indian law that guide the way that laws are to be interpreted. And there's a long history of cases that have been analyzed and determined based on these canons of construction, and long precedent with the Supreme Court in using these canons to determine the outcome of Indian law decisions. And one of them that's really important in this case is that whatever has not been exclusively ceded or abrogated is retained by the indigenous people, by the tribal peoples. And the tribe specifically, it says specifically within the Land Claims Settlement Agreement, the Maine Indian Claims Settlement Agreement, that was once the Maine Indian Land Claims Settlement Agreement, that it only dealt with the lands, which means that our water rights were never abrogated. And so we have volumes of historical documents that recognize the rights of the Penobscot Nation to our tribal water rights and our territorial rights to that water. And those were never abrogated. The one thing that Singhal got right was that he said that the waters weren't included in this agreement. Yes, that's true.
Singhal is the judge.
Yes, because those water rights were never abrogated. We never ceded our water rights. And so, you have all of these things stacking up. And then you have Maine Attorney General who replaced Schneider, Janet Mills, who has been out purposely misleading people about the facts of this case. You have the law firm that's associated with the interveners in this case purposely misleading people about the facts of this case, saying that it's a water quality case and that the tribe is going to try to police people within those waterways. This is a territorial rights case. This is a cultural rights case. This is about subsistence fishing and our subsistence and sustenance way of life. And so them using these scare tactics, the same scare tactics that they used when the land claims was being, the Indians are going to come in and take away your homes, they're going to take away all your rights, and, none of those things happened. And so they're using those same scare tactics now with misdirection and misleading information connected to this case. This is not a water quality case. The state of Maine is engaged in a water quality case because the state of Maine sued the EPA because the EPA said that Maine's water quality standards were not sufficient to support tribal sustenance and subsistence fishing. And so, yes, the state of Maine is involved in a water quality case.
It's a separate case.
But it's not with the Penobscot Nation. It's with the EPA. And so that's problematic in two ways. One, either the Attorney General is not familiar with the laws and facts related to the cases that are coming out of her office with her name on it, or two, she's purposely misleading the public about the facts related to these cases. And either one of those things is problematic, and it either is incompetence or a complete lack of ethics, one or the other. And so this is what we've been dealing with. And so we've been working to try to educate the public about this. And the case has been appealed by both the tribe and the state at this point in time. In my opinion, Judge Singhal kind of passed the ball on this. He gave a little bit to the tribe and he gave a little bit to the state. He said, yes, the tribe does have sustenance and subsistence fishing rights, which are outlined within the settlement agreement, being within the boundaries of the reservation, and none of these river run fish live on the land. So if we have sustenance and subsistence fishing rights within the boundaries of our reservation, that has to include the water. And so, he said, yes, we do have these rights, but we don't have any territorial waters. Those two things are completely in conflict with one another. And in my opinion, he passed the tough decision off to someone else. He knew that it was going to be appealed. He's semi-retired. He's part of this historical good old boys network within the state of Maine. And so he can just ride this out by passing the tough decision on to someone else to make. And that's what essentially happened, in my opinion, is that he did that. He gave a little consolation to the tribe by saying, yes, we recognize that you have sustenance and subsistence fishing rights. And he gave a little bit to the state by saying, but there are no territorial waters within which to do that sustenance and subsistence fishing, even though it's outlined very clearly. There's no ambiguity about that in the Settlement Act.
So it just seems to me that he sort of reached out for some of these decisions that he made, which is, I mean, it's par for the course, because that's sort of been happening all the way through. These judges reach out to sort of keep us under control of the state,
Right.
in their decisions, and they get away with it.
Right. Well, there were a couple of things that were concerning to me about this case, and one of them was the fact that there's been no challenge to the failure to utilize MITSIC as it has been designed to be used within the Settlement Act. You have a statutory obligation to utilize MITSIC to be the arbiter of any type of conflict. And the state of Maine has completely refused to participate whatsoever in any meaningful way with MITSIC in the way that it was designed to be used. And so you have a complete dismissal of this statutory obligation. And it was designed to address issues like this. Also, in the canons of construction, something that Singhal kind of mentioned but failed to execute properly, in my opinion, is that any ambiguities would be resolved in favor of the tribe, and that any ambiguities would be viewed in the way that the tribe would have viewed them at the time that the decisions were being made. If you look at all of the legislative history and all of the historical documents, if you talk to people who were present during that time, it was very clear that the water was never intended to be a part of that agreement. And so not only did he fail on those 2 points, but he also failed with the first canon that we talked about, which is whatever is not exclusively and explicitly ceded is retained by the tribes. So you have all of these things and this gross overreach. Again, it's the creation of legal fiction that is designed to benefit those who wish to take from Indigenous people. That is federal Indian law in a nutshell. When I took my very first federal Indian law class in law school, one of the professors held it up and said, "This is the big book of losses. You're about to go through a semester of being very, very upset when you start to recognize the historical context for the creation of this body of law called federal Indian law, which is larger than any other body of law, which is all specifically designed to take away the rights of Indigenous peoples. And it has been used in this country since the very beginning with the violation of the two highest forms of law, the Constitution and treaty law."
And Marshall, and we only talked about one of those cases,
Right.
but the other two cases that Marshall decided speak to that too.
Right. And that there's one piece of that where they created this form of quasi-sovereign status, this non-citizen citizenship, is the piece that Hitler and the Nazis really latched onto, the non-citizen citizens. And they used that language on non-citizen nationals within the Mein Kampf. And so you have this whole history of manufacturing these legal ideas that were created out of whole cloth, that have no basis in any type of legitimate authority, that have been imposed on Indian people. And it's simply a way to justify the taking.
Yeah, so this non-citizen, citizen,
Non-citizen national, I believe, is how it was referred to in Mein Kampf.
where does that come from? I mean, what? And what is it? And what does it mean? I mean, you're a citizen,
Essentially-
but yet you're not a citizen,
Right,
or-
because the Native peoples didn't have citizenship at that
Right.
time. Native
Yes.
peoples didn't get citizenship within the United States. So we were nationals of the United States. We were wards of the government. This whole guardian ward
Okay.
relationship was established. And we had sovereignty, but it wasn't real sovereignty. It was a form of
Domestic
quasi
dependence,
sovereignty
yeah, yeah.
as domestic dependent nations.
Yeah.
And so this whole illusion was created under the law and perpetuated forward that didn't have any founding in any type of legitimate legal precedent. The whole thing was completely pulled out of thin air and manufactured here. And all of that happened within the Marshall Trilogy. And so, you know, we have this status here, again, as a sketch. We don't have any legitimate
So we've got
citizenship.
all our laws built on fantasy, really.
Yes. Built on fantasy and illusion and sleight of hand.
Yeah, and if I remember right, I think Marshall had an interest in land himself that he kind of wanted to take care of. Do you remember that?
I don't remember that, but it wouldn't surprise me. I mean, those cases essentially were kind of carved out in such a way that allowed the U.S. to retain their interests in indigenous lands. So indigenous lands weren't able to be sold to individual landowners or to other nations. All sale of indigenous lands had to go through the federal government, who was the holder, you know, as a successor in interest to those titles. They were a holder of those titles. So it was carved out in a way that allowed them to maintain that control, so that the states didn't start taking up that land and gaining any additional power. But at the same time, it diminished the rights of the Aboriginal title holders. So it was carved out really, really specifically in order to protect a few people within power.
And then the tribes couldn't own land. They
Right,
could just occupy.
right,
Yeah.
right. They had rights of occupancy, but not rights of ownership or title, and no ability to be able to transfer title to those lands. And then when you get into the Dawson Act and some of these other things that unfolded, which we won't get into all of them because we'd be here for days, but where there were these carve-outs, these checkerboard land ownership schemes that came out of that time period, where there were certain groups who were able to sell their land holdings because individual tribal members were given parcels of land so that they could, you know, become part of the movement.
They did it in Maine. We, the Penobscots, bought into it because you know we have different lots.
Right.
The Passamaquoddies didn't. Their tribes owned land as a whole.
Right. But we're not able to
But we
sell
can't
our
sell
lands.
it. That's right. But
And so under the Dawson Act, they were able to actually sell those lands because they were trying to assimilate Native people. So that was a divide and conquer tactic.
Yeah.
If they could break up the community and the tribe and pit individual landowners against each other in this competitive capitalistic market, then they had a greater chance of being able to take away their larger land holdings, which is what we see actually, a diminishment of that within these checkerboard reservations, where they say, well, there are enough non-native people living within here that tribal law doesn't apply within this territory. And so, you know, there are all of these tactics that were couched under this notion of being able to help Native people, which actually was an attempt to diminish and to further destroy Indian title rights within those territories.
But we digress here. Because
It's easy to do.
I don't.
It's easy
Because
to
we're talking about the river case. And,
Right.
But it kind of all sort of.
It all goes
know?
together. Yeah. And so this is just industrial interests being promoted by the government, which is not a news story here. It's the same thing that's going on in Florida, where industrial interests are being promoted at the expense of indigenous rights. And so when you have an agreement, like when you and I enter into a contract, we have to agree to the terms of that contract, and we both sign and date it on the line. And the four corners of that contract remain intact unless we decide together to amend that, and then we both approve of those changes and we both sign a new amended document. One party to a contract can't unilaterally change the terms of that contract without the express agreement of the other party. And so what's happened here is that the state of Maine is essentially unilaterally, and this is what they've been doing since the very beginning with the settlement agreement, changing the terms based on what their needs and desires are, or what the needs and desires are of other individual private landowners and corporations and industrial actors. And they are determining that the rights that the tribe has can be unilaterally taken away.
You know, you would think that that would abrogate that agreement.
Well, under the law, it should abrogate that agreement. I mean, it should
So how
nullify
do we go about, you know,
that agreement.
bringing that forward? Do we just, you know, I mean, it's just, it's killing us.
It is. And I think that one of the things that is problematic is that you have in place this adoption, like we were talking about, the adoption of this identity of being part of this purified race based on blood quantum. We've also adopted other identities. We have adopted this dependency on the government, and both the United States and state of Maine. And though we might be vocal about our disapproval of it, we haven't really taken a stand of any strength against these issues. And we haven't taken a stand of any strength, in my opinion, because we're continuing to deal with the same line, the same historical line of people who negotiated that agreement on our behalf.
So let's go back to visioning ourselves in the future.
Right.
If we vision ourselves in the future of not being under this act,
Mm-hmm.
what does that vision look like? I mean, because people say, well, if we abrogate this, what's going to happen to us?
Right. People are
Yeah.
terrified of what
Yeah.
it really means to be sovereign,
Yeah, exactly.
because we have adopted this mindset of being dependent. We have adopted this mindset of being the wards or children of the state and the government. And we believe that we are dependent upon them for our survival. And so if we continue to think that way, and if we continue to hold this entitlement rather than having this idea of being sovereign nations who are self-dependent, self-sufficient, and who are able to meet the needs of their people on their own, then we're never going to break out of it. I mean, going forward, what this looks like to me is being able to make decisions for the future of our community that are in line with our cultural and traditional values without asking anybody's permission to do so. We create and enact laws within our territories that are in line with those cultural traditions. We engage in business activities where we're not looking for the state's approval or the state's handout in order to succeed. We don't say, you owe us, and therefore we're going to wallow and we're not going to succeed until you give us what you owe us. Instead of saying, you know what, we need to step forward and we need to create our own direction into the future. We need to create our own opportunities. We need to be working creatively and intelligently with other tribal communities who have succeeded, and look for ways to be able to incorporate that here into our way of being and into our way of governance.
Exactly, and that's why I think it was such an important move for the Passamaquoddy and Penobscots to pull that tribal representative out of the legislature.
Right.
You know, I
Right.
get people say, gee, you know, that was a real mistake. You guys should have just stayed there and, you know,
No.
worked things out and whatever. And I say, no, no, because sitting in that legislature basically made us a political subdivision of the state.
Well, not only that, but a political subdivision of the state that was silent, that had no voice.
Exactly.
Right.
So I think that was the best thing we could have done, was walk out of
Absolutely.
there and figure out a pathway forward that will honor who we are.
Yeah, absolutely.
So-
And I think that, you know, that was such a bold move, and it was such a powerful time. And to have the tribal leaders call them out of session, to be able to be there, to witness the energy of that, the power of that. And it wasn't related to anything other than the recognition and the standing in of our own power as Wabanaki people, as Penobscot people, as having our leaders recognize themselves as leaders of nations, sovereign nations, not as a municipality or ward of the state or the federal government. And it was really emotional and moving for me to be able to be there and to witness and to participate in that. I was so incredibly proud of our leaders, of our representatives, and the strong move that was taken on that day. I mean, the energy of it was palpable.
Yeah.
And that's what we need to step into. That's what we need to embody, not as a symbolic gesture, but as a legitimate pathway forward.
Right. And we need to take the power and the strength of that moment and see it forward.
Absolutely. And we do that by not asking permission to be who we are as
Exactly.
Penobscot people. And not failing to live the way of life that we have historically lived in relationship to this place that we call home.